Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. Our first case today is Dernis versus United States, appeal number 23-2821. Mr. Shapiro.
Good morning. 15 years ago, George and Maria Dernis began an odyssey that would be difficult to predict or describe. What was involved was a corrupt bank, jailed bank officers, an indifferent FDIC, and the hope that today this de novo proceeding will create an opportunity for this matter to be heard. Premier Bank was declared to be unsafe and unsound approximately 15 years ago. In March of 2012, the FDIC receivership came into place with regard to Premier Bank. The attorney for Premier Bank at that time was one Andrew Abrams, who became the attorney for the FDIC corporate, the FDIC receiver, and Amos Financial, the successor, arguably, in interest to the FDIC as a result of a loan sale agreement. At the same time, the Illinois Attorney General and a grand jury were investigating Premier Bank.
Mr. Shapiro, can I ask you about section 2680H? I'm asking you about immunity here.
Immunity does not cover forgery. Immunity.
How so?
It's if I may, with regard to the FDIC had the capacity and the ability to do and exercise reversionary rights and to proceed from that point to mend this situation before it went on the path that it did.
But I guess my concern is, what difference does that make if there's immunity and the FDIC cannot be sued?
The FDIC...
I guess your argument is that they waived immunity? Or they never had immunity?
The FDIC, under its legislation, can sue and be sued.
Right, but that doesn't say anything about immunity.
No, it doesn't say anything about immunity, and I believe, Your Honor, that is the direction in which I am going.
The only defendant at this point is the United States, correct?
That is correct, under the Tort Claims Act.
So 2680 is applicable if it's applicable by its terms. Can you point us to the legal error you think the district judge made?
Yes. The legal error that the judge made was that the documentation that was presented to the FDICR by Premier Bank and then eventually to Amos was void ab initio. If you are to refer to the two decisions that came forward, one in 2023, Landcastle Acquisition versus Renaissance Bank, an 11th Circuit decision in January of 23, and a much-read decision in the Langley case by the United States Supreme Court describing fraud in the factum. The question for me is...
what were those two cases?
Landcastle Acquisition versus Renaissance Bank, 11th Circuit, decided 1/12/23, and the Langley decision at the United States Supreme Court.
Were those in your brief?
No, they were not.
So when we ask you to identify the legal error, you cite cases that are not in your main brief.
That is correct.
I'm speechless.
I'm sorry for that, Your Honor. I can only say what I have before me at this moment in time, a complete history of the misconduct, and whether or not that can be reviewed, heard, or in any way applied to what
Why
is
should we
before
not
you
treat
today.
any argument based on the Landcastle and Langley cases as waived?
Understood, but the principle isn't waived. The principle of fraud in the factum is not waived in this matter. We have contracts that are void due to the forgery of bank officers. We have the exercise of FIREA rights by Amos Financial, which they do not have under the loan sales agreement. We have a failure on the part of the FDIC to exercise their reversionary rights, and we have a complete disaster for a family that has been through more than could possibly imagine, including the fact that Maria is not here today in the courtroom with me, and neither is George. George suffered a massive stroke on September 1st, remains hospitalized and incapable of speech and walking at this moment in time. So what am I asking this panel to do? I'm asking you to review de novo and to look at a fact pattern and send this down for an opportunity to again review it in front of Judge Aspin and to bring forward these matters.
To do that, Mr. Shapiro, you need to identify, and needed to identify in your opening brief, a legal error made by the district judge on an issue that was presented to him. 2680H provides an exception for, among other things, misrepresentation, deceit, or interference with contract rights, correct?
Correct.
How does your allegations about fraud and forgery not come within that language?
The difference is whether or not it is the FDIC understandings both in FIREA and Dench Dumais. Are those the controlling ones, and do they migrate to the United States government for purposes of potential liability? I realize I am asking for something that is somewhat novel, but
Yes.
I have no choice except to pursue it at this point in time as this family suffers.
Would you like to save your remaining time for rebuttal?
I have saved 2 minutes at this moment, if I may. I'd like to point out something that is potentially of significance here. 4 employees of the FDIC, Andrew Abrams, Joseph Scaffin, John Garisco, and Dan Bergen, the criminal investigator, were aware of what was going on here. And 14 months after that awareness hit the FDIC, what happened? The FDIC took these documents, transferred them to Amos, and Amos then exercised FIREA rights, which it does not have. Wherever you may think this case belongs, I think it also belongs as a concept in justice and equity. Thank you.
Okay, thank you, Mr. Shapiro. Ms. Terman.
May it please the court, counsel. The Dernises cannot sue the United States in tort because most of what they complain about in the complaint was not timely presented to the agency, and the narrow allegation that was timely presented is barred by the intentional torts exception to the Federal Tort Claims Act. The United States is, of course, a sovereign, and a sovereign can't be sued unless it consents to be sued, and the United States does not consent to be sued for claims arising out of fraud. The statute in section 2680H exempts torts arising out of, among other things, libel, slander, misrepresentation, deceit, and that's exactly what's pled in this complaint. The Dernises essentially plead themselves right into the intentional torts exception. Everything alleged in the complaint arises out of fraud, and the opening line of the opening brief in this appeal says, the underlying complaint was filed by the appellants to obtain relief from the fraud committed by the United States government. And for that simple reason, the United States remains immune from suit. And if there are no further questions, we'd ask that this court affirm the decision below.
Thank you, Ms. Terman. Mr. Shapiro, do you have anything you'd like to add?
I had only the point that has to be made, and that is the damage done by the FDIC. And it would seem that it would be arguable that the FDIC, which is an entity that can sue and be sued, is a branch of the United States government, and as such, this action should lie.
Mr. Shapiro,
Thank
could I
you.
ask you, was there any recoupment from the convicted owners of of Premier Bank, either in criminal fines or restitution or anything of that sort?
Not that I'm aware of, Your Honor. Additionally, there was a $7 million recoupment in the bankruptcy that succeeded this activity by the FDIC.
From your clients?
No,
Oh, no?
from the sale of assets, the
okay.
disposition of the family's assets.
Ah, okay. Okay, thank you.
Thank you.
Thank you.
Thank you, Mr. Shapiro. The case will be taken under advisement. Our next case is Padua versus King, appeal number 24-1718. Mr. Brown, whenever you're ready.
Good morning, Your Honors. Jim Brown on behalf of appellant. This case is a denial of Social Security disability benefits from which the appellant is appealing. It's important to note in this case that the application for benefits was filed way back in 2010 when she was 45 years old. The reason why that date is important is because the Social Security rules for how they treat or how they deal with treating source opinions, treating doctors' opinions, the old rules were in place at that time. The rules later changed in 2017. In this case, the ALJ found that the appellant had severe fibromyalgia, chronic fatigue syndrome, depression, and anxiety that limited her ability to work, but there were still jobs that are available in the economy that she could perform, so she was found not disabled. One of her main doctors during this period of time was a Dr. Carpenter, who is an internist that she saw about every 3 months. In his report, Dr. Carpenter stated that the appellant had fibromyalgia with pain, stiffness, tenderness, and swelling, and that she would need to alternate positions every 15 minutes. He thought she could sit or stand for less than a full workday. And because of sleep disturbances, she experienced daytime fatigue, and her pain affected her mental capabilities as well, and the pain and medication side effects would affect her ability to concentrate and sustain tasks. There was also opinion by a chiropractor who treated her during the same period of time, and he was also of the opinion that the pain arising from her fibromyalgia and chronic fatigue syndrome would result in her not being able to handle full-time work. It's our first contention that the court erred in affirming the ALJ's decision based on, which were basically, the ALJ's decision was based on a lack of objective findings in a fibromyalgia case. In other words, she was going to doctors, they were seeing.
She was going to a chiropractor and internist. Did she ever see a rheumatologist?
She never saw a rheumatologist. She was referred to a neurologist.
It seems to me that what the ALJ did here, particularly with respect to Dr. Carpenter, is disregard Dr. Carpenter's opinion, at least in part, because Dr. Carpenter's notes and his files just contained a recitation of your client's subjective symptoms. That was it.
That was part of the reason why why the ALJ rejected it.
And what's wrong with that?
What's wrong with it is the ALJ didn't delve into the treatment notes to see.
Well, the ALJ isn't a doctor.
No, but in a fibromyalgia case, where such a big part of the case rests on a person's subjective reports.
But I understand, but Mr. Brown, it's your client's burden of proof, right? And when your client is seeing an internist, and the internist just repeats your client's subjective symptoms, and the internist says you have fibromyalgia, is the ALJ just required to accept that?
No, but she can't just shove it aside just because there are no objective findings. The ALJ has to look at what the plaintiff, what the appellant is really telling her doctors.
I believe that's a correct statement of the law, but can you point us to the language in the ALJ's opinion that you believe reflects a mistaken view of that?
Yes.
She has to look at whether there is objective evidence, right?
The ALJ has to look at whether there is objective evidence, correct. She also has to look at all of the evidence.
Yeah.
And in this case, what I'm suggesting is on the record at page 594, where the ALJ makes her decision, she makes references.
So which page of the opinion of the?
Of her opinion, it would be
Yeah.
page 7 of her
Yeah,
opinion.
okay, I'm there. Thank you.
She makes references to the claimant reporting significant pain and fatigue, but she doesn't go into what she's really reporting. This plaintiff is reporting very severe symptoms. For instance, she's reporting on occasion that she's very tired, she falls asleep at a moment's notice, she doesn't sleep well at all. She gives really stark references in the doctor's notes to how bad the pain is. She says the pain is so bad her organs feel as if they're coming unglued. She says she has pain everywhere, morning stiffness that lasts all day, and her spine feels like it's on fire. These are contained in Dr. Carpenter's notes. Those are at record 566 and record 569. So it's my view that the ALJ, in a fibromyalgia case where the substance, what the person is really telling their doctors is so important, that in this case, the ALJ just generally said she suffered from pain and fatigue and didn't get into the meat and bones, what was really being talked about between the plaintiff and her doctor.
Mr. Brown, can I ask you, as I understand it, the government has made this point, at least somewhere during this period of asserted disability, the plaintiff was attending school to become a massage therapist?
She was.
And how long were those sessions on a daily basis?
That's in the government's brief. They were long enough where, I'll tell you this, the government had a good point, that she was, I think the ALJ said, she says, on the one hand, my client said that she couldn't really drive more than 20 minutes, but on the other hand, though, the government points out she was driving to this massage school for several months, most days of the week. Mm-hmm. I mean, I don't think that is necessarily a good reason for discounting her testimony that she couldn't sustain work. Going to school is different than attending work and being at a job 8 hours a day, 5 days a week. I mean, school is, it's not as competitive as work in terms of sustaining focus and concentration for 8 hours a day, 5 days a week. I mentioned at the beginning about how this is an old case, which is important, and the treating source opinions under the old rules should be given controlling weight when the treating doctor's opinion is well supported and not inconsistent with the other evidence in the case record. In this case, the doctor's opinion, I think, was well considered and consistent with the evidence and should be given controlling weight. I also note that even if the doctor's opinion shouldn't be given controlling weight, the rules at the time said you have to give this opinion deference. You have to defer to it to some extent. In this case, the ALJ did not. She adopted the opinions essentially of non-examining state agency doctors and overlooked the opinion of a doctor who saw this person regularly and saw their consistent complaints of significant pain and fatigue and difficulty concentrating that interfered with their ability to work. I would like to reserve 2 minutes for rebuttal if I can.
Certainly. Okay, Ms. Johnson.
Good morning. May it please the court, I'm Victoria Johnson on behalf of Michelle King, the Acting Commissioner of Social Security.
I was wondering who the new acting commissioner is. King, okay.
Yes. Your Honor,
Is the agency's website being kept up to date as to who the acting commissioner is?
Your Honor, I'm not exactly sure. I haven't looked, but
Okay.
we did submit something to the court indicating with my appearance that it had changed. I don't think it'll be that way for very long. I just wanted to answer your question, Judge Hamilton. She was going to massage school for she testified about 2.5 months, 4 hours a day, 5 days a week, and it was about a 20-mile drive. And then I also wanted to respond to counsel's contention that the ALJ had to give deference to Dr. Carpenter's opinion. The regulations that were in effect at the time don't require deference. It requires the judge to consider whether the opinion should be given controlling weight, and that's in 404-1527, and then the court looks to the other regulatory factors within that. So look at the Judge Carpenter's specialization. He wasn't a fibromyalgia, specialty. He wasn't a rheumatologist. You look at the length of the treatment. All of these things the ALJ discussed in the decision. The court should affirm because the ALJ supported her residual functional capacity assessment with substantial evidence, including giving great weight to the opinions of 2 consultative examiners and 4 state agency reviewing doctors. Ms. Padua's argument that the ALJ cannot consider objective medical evidence when evaluating work-related limitations associated with fibromyalgia does not withstand scrutiny, as we have stated in our brief. SSR 12-2P limits the evidence to diagnose fibromyalgia. However, when there is a valid fibromyalgia diagnosis, the ALJ is required to evaluate the work-related limitations caused by that condition and the claimant's other medically determinable impairments. SSR 12P, the Social Security Act, the agency's regulations, and case law recognize that objective findings can reflect on a claimant's functioning. SSR 12-2P provides that if the evidence does not substantiate the claimant's statements about her symptoms, the ALJ considers all of the evidence in the record. This evidence includes, for example, the claimant's daily activities and treatment notes. Here, the ALJ found that Ms. Padua's testimony on limitations was quite extreme, like needing to rest after every activity, including eating. She fell asleep after riding her exercise bike for 10 minutes. She testified she had to rest 20 minutes to 2 hours after taking a few items out of the refrigerator. The ALJ reasonably reviewed the objective medical and other evidence to determine Ms. Padua's residual functional capacity. The ALJ found, for example, that if eating and riding an exercise bike a few minutes would wear her out, it would be reasonable to expect that going to the doctor's office would do the same. But no physician documented these concerns, such as falling asleep or appearing drowsy or lethargic. Physical examinations generally did not indicate abnormal findings beyond trigger points. Even so, the ALJ partially credited Ms. Padua's testimony in assessing a residual functional capacity that was more restrictive than the opinions the ALJ gave great weight. Thus, the ALJ's conclusions regarding Ms. Padua's symptoms were reasonable and well supported. The ALJ's discussion of Dr. Carpenter's and chiropractor Dr. Pendolino's opinions complied with the minimal articulation requirements. Turning to Dr. Carpenter's opinions, the ALJ reasonably explained the weight she gave to his opinions, applying the appropriate regulatory factors. Ms. Padua takes issues with some, but not all, of the ALJ's valid reasons that she gave for discounting Dr. Carpenter's opinion. To the extent Ms. Padua argues the ALJ should have given less weight to the objective medical evidence and more weight to her subjective allegations, this argument is really asking the court to reweigh the evidence. Here, the ALJ reasonably found Dr. Carpenter's opinions, including that Ms. Padua could not work due to fatigue, not supported by objective findings and treatment notes. The ALJ's findings were sufficiently specific, and the court should look to the decision as a whole. The ALJ found, for example, that treatment notes did not document Ms. Padua falling asleep or appearing lethargic. In addition, Dr. Carpenter always noted she was alert and oriented with appropriate effect.
Ms. Johnson, can I ask, do we know why this case is so old?
I don't, Your Honor, and it's regrettable that it is. I looked into that and I couldn't figure out why. There was a delay at the appeals council. She had requested review.
It was years, right?
Yes, Your Honor, and we regret that. Because the ALJ's ultimate findings are supported by substantial evidence, and Ms. Padua was represented by counsel throughout the process, and that hasn't been raised in the appeal. The decision is sufficient to allow the court to assess the validity of the ALJ's ultimate findings and afford meaningful judicial review. If you have no further questions, we ask that you affirm.
Okay, thank you, Ms. Johnson. Mr. Brown, do you have anything you'd like to add? Okay.
Yeah, a couple things. I appreciate counsel clarifying the massage school question that Judge Hamilton had. You know, I note that basically if she was going 4 hours a day, 5 days a week to massage school, that's not the equivalent of a full-time work schedule, so I don't think it's indicative of
I understood the argument to be more that that activity was simply inconsistent with her subjective complaints of pain and fatigue, where she was saying she could not drive down the block, for example.
Right. I would say that in fibromyalgia cases, symptoms wax and wane over time, and that there could have been a time during the period of time where she could do a little bit more, but never to the point where she could sustain full-time work.
Mr. Brown, all the cases we see are cases in which benefits were denied. Are there fibromyalgia and Epstein-Barr cases where benefits are awarded?
Of course, Judge, and I'm not just saying this because I'm standing here in front of you, but it would be this kind of case where she's complaining about her symptoms in very stark terms to the doctor. She's saying, this is bad pain. I feel as if the pain is so bad, my organs are coming unglued. My spine feels like it's on fire. These are things that she's saying. So I think this would be the kind of case that could be approved, but it depends on the ALJ. A couple things I'd like to point out, that there is, under the rules that were in place at the time, 96-2P, SSR 96-2P did in fact say that treating source opinions, even if not given controlling weight, are entitled to deference. They have to be given some deference. So I do think that because of the way the judge treated fibromyalgia and the way the judge did not give controlling weight to the treating source opinions, that this case should be remanded for further proceedings.
Thank you, Mr. Brown. The case will be taken under advisement.
Thank you.
Our third case today is Pratt versus Wisconsin Aluminum Foundry, appeal number 24-1901. Mr. York, whenever you're ready.
Good morning. My name is Nicholas Yerk of Allen C. Olson Associates, and we represent the plaintiff appellant Deborah Pratt. Ms. Pratt brought claims of discrimination and retaliation under Title VII of the Civil Rights Act against her former employer, Wisconsin Aluminum Foundry Company. On summary judgment, the district court dismissed Pratt's claims based on a flawed and incomplete analysis of the record. We ask this court to reverse the district court and allow Ms. Pratt to bring her claims to trial. Each of Ms. Pratt's claims is well supported by existing Seventh Circuit precedent and the facts of the case. This case doesn't require any novel legal theories or extensions of...
Mr. York, can I ask you some questions about that, about your legal theories in this case?
Absolutely.
And I want to focus only on the retaliation claim, okay? She proceeded under the McDonnell-Douglas burden-shifting framework, I think. And the first element of the prima facie case is that she engaged in activity protected by the statute, meaning she opposed sex harassment, okay? The way I understand it, your argument is, it seems to me that you concede, at least in your reply brief, that just because you're a human resources manager and you report sex harassment or what you perceive to be sex harassment doesn't mean that you opposed it. Is that right?
I think that's certainly correct, and I think Ms. Pratt certainly opposed...
Right, I know that's your argument, but you concede at least your argument is not that just based on her position as a human resources manager, she necessarily opposed harassment by reporting it, right?
Our argument is that she herself reported harassment against herself, and in making those reports necessarily opposed sex-based harassment.
Okay, and you concede, I think, that the sex harassment that she opposed was not severe under our case law.
I don't think we do concede that.
Well, what about it? Okay, what's your best case for the position that anything that she opposed was severe under our case law?
Certainly. I don't think, one, that you need to look at any specific instance of harassment or discrimination.
Well, that's pervasive.
And so I would say the most severe instance of discrimination she opposed was actually race-based discrimination. If we look at the situation involving...
Did you make a race claim?
No, he made a claim for retaliation in general under Title VII. And my concern is that the district judge seems to have overlooked a number of the instances of protected activity that were identified in your brief and summary judgment materials, including the Yang race incident.
I think that's absolutely correct.
There's no doubt about that, but we're Article III judges. Can't we consider them? I mean, I'm with you. The district judge ignored some of that. And he didn't explain the sham affidavit rule and things like that. There's no doubt the district judge overlooked some of that stuff, but can't we consider it on appeal?
I think you certainly can, but I think, again, looking at the record as a whole, the examples of discriminatory and harassing conduct that she opposed were both severe and pervasive. And I say severe and pervasive, but the case law only requires one. And so...
Does the case law for retaliation, does the case law require the plaintiff to show that the conduct opposed actually amounted to a violation of Title VII?
So the case law only requires that a plaintiff have a subjective belief.
Reasonable and subjective belief, correct?
Correct.
We've said that time and again.
And
is it also correct that when you're dealing with instances of harassment and the kind of an environment that Ms. Pratt described in her deposition, that there can be cumulative effects, that no single instance has to violate Title VII in order to add up to a concern? In this court's employment policies, for example, we try to deal with harassment incidents long before they might become legally actionable.
I think that's absolutely correct. We're looking at all of the evidence that suggests retaliation or discrimination as one pile, and the question before this court and before the district court is whether a reasonable fact finder could find that an inference of discrimination or retaliation was appropriate. And again, there are severe examples of discrimination and retaliation that Ms. Pratt complained about, and these weren't things that were brought to her as an HR manager. These are independent issues that she is identifying.
Mr. York, what's your best argument that a reasonable person would have believed that anything on which she complained altered the work environment?
So I would say with regard to a manager that was discriminating on the basis of race, she reported that he had both fired and attempted to fail to promote an employee based on race, and had directly said that it was because of their race. This is Mr. Culp. He had first told an employee that he was going to be denied a promotion because he was Asian. He then disciplined a Hispanic employee wrongfully a few days later. And then third, this same manager fired an African-American employee on with no basis.
Wait. I think you're at least I didn't get this from your brief. I thought that her complaint was that he fired a Hispanic employee without HR process. Not because he was Hispanic. Which is it?
So it is that she believed that there was racial discrimination at play.
Why did she believe that?
She believed that there was racial discrimination because there was a clear pattern of him treating minority employees differently than he treated white employees.
So, and you can point to the clear pattern is him firing a Hispanic employee without HR process, him mentioning to Cedric Yang that he was passed over promotion because he was Asian, which I think she conceded it may have been a joke, and that he wrote up a black employee for inaccurate reasons. That's it, right? That's it.
Along with not, I guess, pursuing similar actions or having a similar reports involving his white subordinates. Yes, he was treating his minority employees differently than his employees who were, he was treating his minority employees differently than he was treating his white employees. And that's the basis of a discrimination issue under Title VII. Ms. Pratt independently reported that discrimination issue was occurring and that she was concerned that the company was discriminating against workers on the basis of race. That is, I would say, the clearest example of severe conduct. And again, there's certainly pervasive conduct here as well.
Do you think that any of these instances amounts to severe under our case law?
I think
Which ones?
I think firing an employee on the basis of their race.
That's a category mistake. We don't ask about, if somebody's fired because of their race, it violates Title VII, period. We don't ask about severity or mildness or et cetera. Now, maybe it was a joke, maybe it's not, that a jury would have to decide that. But you don't have to have, quote, we don't distinguish between severe and mild instances of discrimination. That's a hostile environment category.
I guess I think that's...
Yeah, but I'm unclear again on what is her argument, that she opposed what?
She opposed discrimination on the basis of race, along with discrimination based on sex, along with a hostile work environment. I would say she opposed numerous categories of action prohibited by Title VII, made these reports directly to her supervisor, tied these reports to retaliation she was suffering in the workplace, and then after tying it all together in an email, was fired a week later. That's the nature of our claim here. And it looks like I have...
We'll give you some rebuttal.
Sorry, what was that?
We'll give you some rebuttal.
Oh, thank you.
You're
All right.
welcome. Okay, Mr. Driscoll McEachron.
Thank you, Your Honor. May it please the Court. Jim Driscoll McEachron on behalf of the EEOC. I'd like to address three issues today. First is that human resource managers are not subject to a different protective activity standard than other employees. Second, the appropriate hostile work environment standard. And third, how a jury could find under the appropriate protected activity and hostile work environment standards that Pratt engaged in protected activity. I'd like to pick up with a couple of questions that the panel had with regard to the acts Ms. Pratt complained of. When to engage in protected activity, it's critical to note that Title VII does not require the discrimination to be complete for the protections from retaliation to kick in. When one opposes employment discrimination that's in progress or a conduct that, if repeated, could rise to the level of a hostile work environment, that may be protected activity. So that's one of the errors that the district court made here in assessing whether or not Ms. Pratt engaged in protected activity that opposed a hostile work environment. While the district court assessed using a hostile work environment standard, it looked for a complete hostile work environment, and it articulated the standard, as the foundry concedes, as requiring severe and pervasive harassment. Of course, that's severe or pervasive, and that standard is a sliding scale. The more pervasive the acts of harassment are, the less severe they need to be, and vice versa. The district court also looked for an intent to harass, and that is not an element of a hostile work environment claim. That claim focuses on the subjective and objective effect of the harassment. So in assessing those acts, the district court looked for evidence that was not relevant to the claim, did not examine all the acts, as this panel has already discussed, of potential harassment that Ms. Pratt reported was a potential sex discrimination and harassment and race discrimination. And the panel asked earlier about the human resources manager role, whether it made a difference whether or not Ms. Pratt was a human resources manager. And it's our position that it does not. The foundry continues to argue on appeal that her job duties limit her opposition.
Could you focus on, let's say, the Second Circuit's opinion in Littlejohn? Or do you agree with the approach that court took in that case to an HR manager's retaliation claim?
Your Honor, Littlejohn's a complicated case. It starts by explicitly rejecting the human resources manager rule. I believe that's on page 317 and note 16 of the opinion, because it says job duties are an opposite to
There's
the
no
opposition
statutory
outcome.
text for excluding HR personnel.
Exactly right, and you can see that in the decisions in Patterson, DeMasters, and Jackson as well. But Littlejohn nonetheless goes on to say that human resources managers have to actively support people complaining of discrimination because of their job duties. So there's two errors in that analysis. The first is it's already concluded, consistent with the Sixth Circuit and the 11th Circuits, the job duties do not affect whether or not someone engaged in protected activity. And as you noted, that's entirely consistent with the text of the statute, which contains no exception or modification for HR managers. It also requires active and consistent support. But the Supreme Court in Crawford rejected an earlier Sixth Circuit opinion that said that opposition needed to be active and consistent. So we would argue that the Second Circuit was correct to say that the manager rule doesn't apply, and for the very same reasons articulated about the manager rule there, you should not look for more for protected activity for HR managers. Like every other employee, they should be held to the Crawford standard.
Would you agree that relaying another employee's complaint is not sufficient by itself?
That's a fact-specific analysis. Our focus would be how that stacks up. Does the communication, communicate a reasonable good faith belief that an unlawful employment practice is occurring? Some reports of discrimination may do that, and some reports of discrimination may not. But the point is that you want to analyze those communications under the same standard that Title VII provides to protect all employees from retaliation. And as the court noted earlier, that's consistent with the requirements for early reporting set out in Farragher-Ellerth. We do want reports of harassment to take place earlier rather than later, and we don't want to put employees and HR managers in catch-22s where they would be subject to retaliation for trying to report early harassment. Briefly, applying those correct standards, so looking for when the district court assessed the hostile work environment standard, we went through the legal errors it made. We do think that this should go back for a fact finder to determine whether or not Ms. Pratt engaged in protected activity. She made repeated reports of sex-based discrimination and harassment and reports of race discrimination. And a jury could find that she subjectively believed those reports constituted discrimination and that she had an objective belief in that conduct, for example, with the sex-based harassment, that if repeated would constitute a hostile work environment. And the same is true with regard to the race discrimination. When you report that a promotion decision may have been made because of race, that is the kind of If I may finish my sentence, I apologize.
Go ahead.
That is the kind of communication that Crawford said virtually always constitutes protected activity.
Okay,
Thank
thank
you.
you. Mr. Yellen.
Good morning, Your Honors. May it please the court. Mike Yellen on behalf of Appellee Wisconsin Aluminum Foundry. Judge Griesbach correctly granted summary judgment to the Foundry here on Pratt's 3 separate Title VII claims. 1, sex discrimination related to her termination. 2, sex discrimination based on pay. And 3, retaliation related to the termination of her employment.
Counsel, I want to jump ahead to the retaliation claim. That's been our focus this morning. Question about the record. I saw that the affidavit from Mr. Jacobs saying that he made the decision to terminate Ms. Pratt prior to March 7th. Is there any other evidence that was produced during discovery in the record that supports the timing of that decision being made before March 7th?
There is not, and I would submit to you, Judge, that no other evidence is needed. That evidence is undisputed. Jacobs' declaration...
Isn't it a little, it's a little vague, right? It says
And
prior to...
He didn't even remember when he fired her when he was being deposed, right?
He was not asked that, Judge, specifically. So...
No? He asked, when did we terminate? And the response was, that's a question for you, right?
If that's the testimony, I won't disagree with you. But with respect to the timing issue, which is how I understood your question, I apologize, Judge, there is no dispute that Mr. Jacobs, his declaration says, before I received that February 7th, 2019 email, I had already requested approval to terminate.
You mean the March 14th email?
Sorry, March 7th.
7th email, sorry.
Yeah. Before I received that March 7th, 2019 email, I had already determined that I was going to terminate Pratt and had requested approval to do so. That declaration is based on personal knowledge of a concrete event. He's saying one thing happened before another.
But was it via email? Was it in a phone conversation? Who was it to? I mean, it's so vague.
I would disagree with that respectfully, Judge. Those questions could have been asked at his deposition if there was any basis, if that was disputed by Ms. Pratt.
But didn't Judge Hamilton just say he didn't remember at his deposition?
He wasn't asked about when specifically did you make that decision. Was there an email chain about it? Was it a telephone call? Those questions weren't asked. So his declaration, which is based on personal knowledge, stands unrefuted.
There was obviously a lot of protected activity before the March 7th email as well. Could I ask you about the sex discrimination case regarding termination? The district judge seemed to think that claim was waived. Pages 3 through 9 of plaintiff's summary judgment brief in the district court are all about that.
And again, Judge, I would respectfully disagree. While the heading purports to address sex discrimination based on termination, the arguments are directed towards retaliation and saying that...
When her comparators are all male in that discussion, for example, the other folks who were criticized in the UTEC report?
There is a vague reference, yes, Judge, to unnamed comparators in the UTEC report. That's certainly true.
Well,
but
it's a short list.
I would submit to you, Judge, that argument is perfunctory and not developed, and I believe Judge Griesbach made that point.
What's the page limit for briefs in the Eastern District of Wisconsin?
30 pages, I believe, Judge.
Okay, interesting. Okay, and she also identified a lot of protected activity in her brief that the district judge didn't seem to pay attention to, or at least discuss in his opinion.
I would submit, and I don't know precisely what Judge Griesbach was thinking, but what I would say is both...
Chief Judge?
Sorry.
In our last case, the briefs referred to Chief Judge Pamela Pepper of the Eastern District of Wisconsin as Magistrate Judge Pepper, and you just referred to Chief Judge Griesbach. I'm a little confused as to who's who. I thought I knew in the Eastern District of Wisconsin, but go ahead.
And sorry, Pamela Pepper, Judge Pepper was the Chief Judge. If that has changed to Judge Griesbach.
It has?
Then I apologize. I don't believe at the time of this decision he was the chief judge. But I would submit that Chief Judge Griesbach focused on the February 18th investigation and the March 7th, 2019 email, because in her briefs to the district court, Pratt, with respect to causation, only argues that there was a causal connection between the February 18th investigation and the March 7th, 2019 email. And that would explain why Chief Judge Griesbach focused on those two events.
Do you agree that a plaintiff can bring a retaliation claim without having to prove an underlying violation of Title VII?
I do agree with that. I think the case law is clear that as long as she has both a subjective and objectively reasonable belief that discrimination is occurring, that would.
And would you expect an HR manager to take action on reported instances of harassment or race or sex-based hostility before they become severe or pervasive?
I think the record is clear here, Judge, that is certainly was part of Pratt's job to investigate complaints that she received. I will say, while we're focusing on alleged protected activity, I think, you asked about this incident with Cedric Yang, and there's no record evidence that incident was reported to Mr. Jacobs. And same with this firing of the Hispanic employee in March of 2018. I don't think there's admissible record evidence that was reported to Jacobs. And so you cannot lump all of this protected activity together. You have to look at specifically what's being alleged. And as we argued in our brief, much of that is barred by the sham affidavit rule as well.
And speaking of the sham affidavit rule, so I've read Ms. Pratt's deposition. Where is she taking a position that is different from what she said in her deposition?
I think we call it out in paragraphs 25, 29, 34, 41, 50, and 54 of her responses to the Foundry's proposed findings of fact. And I do apologize, there's a numbering issue there. Somehow our responses were off by one. But one example I have here is with how Pratt is attempting to characterize these events. So if you look at paragraph 54 of Pratt's proposed findings of fact, she claims she reported this to Jacobs and told him it was unacceptable sexual harassment. But when you look at what she said in her deposition, there's nothing about sexual harassment there.
Where is that in the deposition? What are you referring to?
That's at page 203, 13 to 20. So she says it's disgusting, but there's nothing in that deposition testimony about her expressly claiming that's sexual harassment.
But wait a minute, that's about Emily and Colbeck?
Correct.
I thought we were talking about the Boyd instance. But
So I was giving you one example,
Okay.
Judge, but if you have questions about the Boyd investigation, I'm happy to address those as well.
so somebody needed to figure out that she needed to be more specific, that a man sending a female employee "you smoking hot" email was sexual in nature.
Our dispute is that in her proposed findings of fact, she claims that she expressly said that was sexual harassment, and that deposition testimony doesn't support that she said this is sexual harassment.
How detached from reality do we expect people to be in management? How explicit does the complaint need to be?
Well, all we're saying is, in her proposed findings of fact, she's saying expressly that she reported that as sexual harassment, said it's sexual harassment, reported that.
That was brought up with Ben, and I complained about that, how we, and I presume I would read kindly, as women, were being treated. What more needs to be said there? How is that a sham affidavit?
I'll move on from that point. I think.
Okay, what's your best one?
In terms of the sham affidavit?
Yeah.
I think there are a couple of different examples. So one is that particularly with respect to the issues we were talking about before, the write-up of a black employee and firing a Hispanic employee in March of 2018, neither of those, the testimony shows, were reported to Jacobs. There's no testimony about that. And I would submit to you, Judge.
Was there, in essence, what I will call door closing questioning of Ms. Pratt during her deposition? That I read a lot of instances where she's being asked things. She said, "That's what I remember as of this moment," and I didn't see the door closed to future additions.
I don't know specifically whether she was asked, is there anything else, or for each of these?
Isn't that kind of essential if you're making a sham affidavit argument?
I would respectfully say she was given an opportunity and asked to explain what she said at her deposition. She gave as complete a recollection as she could in her affidavit attempts to add to that and change that. But
In a way that Mr. Jacobs' affidavit, for example, about the timing of the firing decision does not?
I would respectfully submit that those are two very different
Okay.
things. But I'll move on, because even if we concede that there was protected activity here and you assume that there was, there's no evidence of causation. And specifically here, and below, Ms. Pratt argued there was causality as to both the February 2018 investigation and her March 7th, 2019 email. That's all she talked about. So with respect to the February 2018 investigation, as Judge Griesbach correctly concluded, that single event was not protected activity because it involved a single isolated joke. Even if it was protected activity, that happened over a year before Ms. Pratt was terminated in March of 2019.
And yet the decision to terminate her cited information on incidents that had occurred as much as a year before, correct?
Correct. The decision to terminate
So how is it causality for firing but not for retaliation?
I would respectfully answer that as this court's jurisprudence with respect to causality makes very clear that a time gap of even a couple months is sufficient to rebut any inference of causation.
Sometimes, but if the decision maker is showing a long memory, his reasons, the reasons he's taking for firing, I'm not sure that the court should disagree. Can I ask you about the UTEC report, the UTEC group report? This has to do with the sex discrimination claim. Obviously, there's some quite critical things said about Ms. Pratt in that report. But as I read it, it's critical about virtually everybody. And everybody else in there is male, and she tells us that everybody else in there got good reviews and a bonus, and she got fired.
I would respond to that.
Including on lack of trust, right?
I would respond to that a couple of different ways. There were other people who were mentioned in the UTEC report as having a lack of trust. Those people were all part of the executive team, so they weren't on her level. They were not direct reports to Mr. Jacobs.
Including Mr. Jacobs himself, right?
Correct.
Lack of trust, confidentiality, shares information with others that was told to him in confidence.
That's correct.
But he fires her for it.
Was Mr. Jacobs an HR manager?
He was not. And Judge Kirsch, that's a great point, and I was going to bring it up in responding to Judge Hamilton, is all of the folks in the UTEC report had different jobs, different job responsibilities. And Judge Griesbach, Chief Judge Griesbach, went through and did a detailed review of that and found that all of the strengths and weaknesses for these various managers in different roles were much different than Ms. Pratt received. And I would also say the UTEC report was just one part of a bigger analysis of Ms. Pratt's performance, which included many other issues that none of the alleged comparators suffered from.
Including whether she was doing a good job on benefits?
That's right, yes.
And her 2018 performance review said that she did that well, correct?
It said she was good on the benefits side,
Yeah.
Judge.
This is pretty messy, frankly.
I think the reality is oftentimes in reviews you're looking for something good to compliment someone on rather than just only focusing on all negatives. I think the overall review is clear. Ms. Pratt received a 10 out of 32 on her overall ranking and a 0 out of 2 for honesty and integrity. And the honesty and integrity and trust issues are really what's critical here, particularly in her role as an HR manager.
Counsel, I want to direct your attention to another email that Ms. Pratt sent, and that was on February 22nd of 2019 to Lori Herzog on the board. In that email, she complains, in reference to the UTEC report, there was some good old boy club stuff going on. That sounds to me like a complaint of sex discrimination. How do you interpret that?
I see my time is
statement?
up. May I respond to your
Yes,
question?
if Judge Kurtz
Yes,
will permit
yes,
it.
of course.
I would say a couple of things about that. There's no evidence that this is not a cat's paw theory case. It hasn't been argued or alleged, and so there's no evidence that Ms. Herzog was involved in Mr. Jacobs' decision to terminate. So I think even if Your Honor is correct that that was a complaint about sex discrimination, there's no causal link to the ultimate decision to terminate.
Okay, thank you. Thank you, Mr. Yellen. Mr. Yerk, we'll give you 2 minutes of rebuttal.
Thank you. As an initial matter to address the sham affidavit issue, the incident that was cited to involving Mr. Culp, during her deposition, Ms. Pratt specifically referred to her notes that she kept contemporaneously when asked, is there anything else you remember, or questions to that effect. And in those notes, she makes it clear that...
By the way, just to be, the notes were being used at the deposition, right? Everybody had the notes.
Correct. That is correct.
Doesn't that deal with the sham affidavit issue?
In the sense that it...
Everyone had them. Everything that she complained of, everything she talked about in the affidavit was in the notes that everybody had at the deposition. They could have asked any question they wanted regarding the notes, right?
I believe that is correct.
That's your point, right?
I think it forecloses on the sham affidavit rule discussion. Yes, correct.
And the district judge didn't rely on the sham affidavit rule, did he?
I don't think the district judge did. The district judge simply didn't discuss those incidents at all. And so we're left sort of searching for, why were these disregarded? And that's why this sham affidavit
Can
rule
you
being
address
discussed.
Mr. Yellen's argument that regarding causation, that the only argument that Ms. Pratt made regarding causation was the February 18 events and the March 7th email?
So I don't think that's necessarily correct. I think that the chain of causation is longer and more detailed than that. I think those were the focus in replying to the summary judgment brief, because those were the focus of the motion for summary judgment. And so I think those were certainly discussed, but I don't think they were exhaustive, and I don't think there's any argument they were exhaustive. They were examples. And I think discussing that March 7th email, there's sort of a conclusory allegation from Jacobs in his affidavit that he had made this decision sometime before March 7th when this email was sent. That's not supported by any documentation whatsoever.
But it doesn't need to be. It's just supported by his testimony, and that's enough. We have two things. Evidence consists of documents, witnesses. Documents, witnesses. Witnesses' sworn testimony is the same as a document. You don't have to have documentary proof of everything.
I certainly acknowledge one doesn't need documentary proof, but you need more than a sort of bald conclusory statement that you made this decision in some undeterminate time in the past.
Would that amount to the
before-
plaintiff as well, that the plaintiff can just say he's lying and that's enough to get to trial?
I don't think so, and it's the same sort of issue. The plaintiff and the defendant should be held to the same standard there. Ms. Pratt had detailed and specific, and I see I'm out of time. Can I
Go ahead,
respond?
yes.
Yeah, Ms. Pratt had detailed and specific allegations grounded in time as to her reports. Their affidavit in response is simply, we made this decision before that. No explanation, no support, no even detail that one could question him about as to when he made that decision. It's a conclusory statement, and it shouldn't be given weight.
What was the timing on Jacob's deposition, the affidavit, and the summary judgment briefing.
Can I respond? to
Yes,
that?
yes, of
Sorry,
course.
yeah.
Sorry, yeah, of course, of course.
So the deposition occurred before the summary judgment motion, and the summary judgment motion included the affidavit that we're discussing here.
Okay, thank you.
Okay, thank you, Mr. Yerk.
Thank
What
you.
case will be taken under advisement? Our next case is Norweathers versus U.S., appeal number 23-2406. Well, Mr. Roy, whenever you're ready.
Good morning, Your Honors, opposing counsel, may it please the court. Michael Roy on behalf of appellant Ronald Norweathers. The district court erred when adjudicating two of Mr. Norweathers' collateral claims for relief. First, Norweathers established that trial counsel was ineffective by failing to request a entrapment by estoppel or apparent authority instruction. And second, the court should have granted an evidentiary hearing on the separate ineffective assistance claim regarding the forensics expert. I plan to start with the forensics expert unless this court has other questions. So the first point I want to make is there is a dispute about the standard of review. I realize that normally whether a district court holds a hearing on a 2255 motion is subject to discretion, but in this case, the court simply overlooked the claim. And this isn't something where the claim was buried within his pro se proceedings and like hard for the court to find. The government also flagged the claim. It was fully briefed by both sides. The court just simply overlooked it. So with no discretion to review, I would ask this court to take its own fresh look. Just do
Mr. Roy, there's no dispute here that trial counsel retained an expert
That's exactly right.
and met with the expert,
That's
right?
right.
And then decided not to call the expert at trial,
That's correct.
right? And why is that not just trial strategy? Like routine.
Well,
and I suspect I know why he didn't call the forensic expert, okay? But why is that just not routine trial strategy that happens in every single case?
Well, I would say that we actually don't know why at this point he didn't call the expert. And since this is a pleading stage, he does allege reasons that would show ineffective assistance for why his attorney didn't call the expert.
But I mean, I guess what's the limiting principle that you propose here? You have a 2255. My counsel did something at trial that I didn't like, and therefore I deserve an evidentiary hearing in front of a district judge to explain that my trial counsel's strategy was ineffective.
Oh, no, that's not at all what we're saying. I mean, there was 15-ish. It's hard to say how many claims exactly there was. Only 2 of them have certificates of appealability. I filed the motion to expand the certificate for this forensic expert claim. We didn't ask to expand the certificate for many of the other claims.
Right, no, I got it. What's the theory, though? I mean, there's no dispute that trial counsel hired an expert, retained an expert, spoke with the expert, and then decided not to call the expert. Why does that not end the inquiry under ineffective assistance of counsel?
Well, if that's all that Mr. Norweathers had said, I agree that would not state a claim for ineffective assistance. But the difference is that he's also saying that his attorney didn't call the expert because he didn't understand what the expert's report was. That makes this more similar to Dunn, this case. Go ahead,
Well,
Judge.
so then why, what am I missing? I'm looking for what the expert said. Instead, what I see is the defendant, petitioner, saying what he thinks he would have said. But I don't see, if there's a report from the expert, why isn't it included?
Mr. Norweathers does not have a copy of the report from the expert.
Does he know what the expert said?
Yes, but it's based off of his recollection. He's been in prison for about 15 years. He's been transferred at least 4 different times. Most of what he has copies of is stuff that can be pulled off of Pacer.
So I think we agree it's not enough for 2255 or for that matter a 2254 petitioner to say if an expert were to look at this, I think we could find an expert who would show that my conviction should be set aside, right?
Oh, absolutely not. But that's not all that he said in this case. He alleged more specifics about what he was able to get from looking at the report from the expert. And it's like there are very specific allegations that when the government did its initial review on site, it compromised the hard drive. And I mean, it's not necessarily, the government frames it as like an allegation of a grand conspiracy, but I mean, it could just be a simple mistake that they didn't put the right blocker on when they first started looking at things. There was evidence of a system restore function that would have not been possible if the right blocker had been put on. There's evidence that maybe some of the emails were deleted. He says specifically on December 21st, 2009, there were emails deleted. These are all things he's saying he got from, yes, his own review of the evidence, but also from the expert's review of the evidence and his communications with the expert. And there's corroboration in the record that it wasn't simply trial strategy. I mean, I think that the main thing I'd point to is the big pro se motion that's filed at docket 180 of the original criminal case, where his trial attorney, in response to a motion in limine that had nothing to do with the subject, says, you know, this is something that my client wrote for me a while back. I didn't file it before, and here I'm going to file it now as a response to this motion in limine. Nothing to do with the motion in limine. But there is Norweather's trying to make in his pro se filing his own arguments about, you know, the cache file, Yahoo records cache, thumbnails, things about what the locations on the hard drive show, things that he gleaned from the expert. Counsel apparently thought those were good enough arguments to sign his name to Mr. Norweather's motion, but counsel didn't elaborate upon them. He didn't make his own arguments based off of them. He didn't do anything substantive himself. He just admitted that he was repeatedly filing Norweather's his own pro se filings.
Is there any element of harmless error review with respect to this particular claim based on Mr. Norweather's testimony?
Oh, no. I mean, I'm guessing you're saying because he admitted that he had sent the files?
Yeah.
No, because part of his claim is that, as he talked about during his trial testimony, he tried to bring up arguments about how the files being located in the Yahoo file sharing cache folder or Yahoo Messenger cache folder corresponded with someone not saving the images on a hard drive, but instead like taking the images and sending them on to someone else. They were only saved as temporary files on the computer. That corresponds with his claims about...
I got it, but his testimony is quite... I mean, look, he was on supervised release. He was a convicted sex offender, and he claimed that he was working undercover with an FBI support person to entrap and ensnare people in child pornography, right? That was the gist of his testimony.
Right. And I mean, so I think this goes to, I guess, the prejudice on both of the claims. Right. Is what you're getting at.
I guess it is. I guess it does. It clearly goes to. I'm asking about the forensic claim. If we should consider it there. I mean, the other claim, the parent authority. I mean, I guess
with the forensic claim, the issue is the only thing we can point to about what his arguments were made at trial regarding how the locations of the images on the hard drive corresponded with sending the items to Bonesuck instead of saving them. It was an outburst he made in response to a question while he was testifying. It's not at all what an attorney who was actually presenting that argument with an expert would have presented. I think that makes it closer to the Supreme Court's case in Hinton versus Alabama, where he's bringing in some of the same evidence through testimony, through his own testimony, but an outburst on the stand from someone the jury knows is a felon and convicted sex offender and bank robber isn't the same.
Who was on pre-trial, or was supervised release?
He was on
right?
supervised
so
release.
So he couldn't act as a cooperator. And I think his probation officer testified to that, right?
Or
there was evidence.
There was evidence of that, yes.
He couldn't do what he said he was doing.
Well, I'll then pivot then to the prejudice on the second claim.
Do you want to save some time for rebuttal?
Sure, I'll just answer your question very quickly. Regarding him not following his rules of supervised release, no doubt that's a technical violation of supervised release. Apparent authority, the question is whether his reliance on Bonesuck was reasonable, not whether he reasonably followed his conditions of supervised release. So being able to show that he did technical violations, maybe he could get revoked for doing that. But there's a difference between technically violating supervision conditions and committing a new offense.
Yeah.
Right.
Okay, thank you.
Thank you.
Okay, Ms. Murphy.
May it please the court, opposing counsel. My name is Madeline Murphy. I'm an assistant U.S. attorney, and I'm asking this court to affirm the district court's denial of the Section 2255 petition on both grounds. Number one, since the defendant failed to show a reasonable probability of a different outcome on his argument concerning the computer forensics expert, and number two, similarly, that he failed to show a reasonable probability of a different outcome had the jury been instructed on an apparent authority instruction. Concerning the court's decision to deny the aspect of the petition having to do with the computer expert, the defendant's claim, or the petitioner's claim, was A, that his attorney failed to consult enough with the expert, and B, that his attorney failed to call the expert. And as the court has pointed out in its questions, Norweathers has failed to show a reasonable probability that a computer forensics testimony would have changed the outcome here. It's his burden to come forward to show the second prong of the Strickland test, that there's a reasonable probability of a different outcome here. And he has failed to show what the computer forensic expert would have testified to. He does raise a lot of technical issues and computer forensics type issues, but fails to connect that up with any specific exculpatory evidence.
Am I remembering correctly, this is the case where the defendant's laptop was stolen from an agent's car?
That's correct. The evening of the search of the defendant's workplace, the agent seized a work computer and a laptop computer. The laptop computer was placed in the trunk of an agent's car, and it was stolen. That is correct, Your Honor. And
in the examination of one of these, of the computer that was left, they failed to use a write blocker or to preserve the condition of the computer, is that right?
It's my understanding that they did use a write blocker. Norweathers contends that the write blocker could not have been used for a variety of reasons that he raises in his petition, but there is testimony at trial to the effect that the write blocker was used. Norweathers testified at trial that the primary documents supporting his claim of working with the FBI were on the lost or the stolen laptop. He did not testify at trial that those documents were on the work computer that is the issue here concerning the computer forensics report. So his contention that he doesn't raise until his reply brief any claim that there was some exculpatory evidence on the work computer that is the subject of the computer forensics claim. But what we know here is that his attorney did consult with the computer expert, did receive a report from the computer expert, and then chose not to provide any testimony concerning the computer expert. And in most instances, as the court has already pointed out, where a defense attorney receives an expert report and opts not to present that testimony at trial, it's because it is not exculpatory, or in some instances it might be inculpatory. The defendant hasn't met his burden of showing a reasonable probability that that expert report would have been exculpatory here. On the issue of the apparent authority jury instruction, the district court applied the correct test in considering and rejecting the claim on the Section 2255 review that even a jury properly instructed on the issue of apparent authority, no rational jury properly instructed on the issue of apparent authority would have acquitted here. Essentially, there was plenty of evidence in the record to the effect that the defendant's testimony on this issue is just patently incredible. He testified that he was told by his probation officer that he could not act as a confidential informant. He admitted that he could not repeat to the jury, the district court at trial, how specifically he found the Joseph Bonsuk on the internet. He found him in some sort of a chat room. He claimed that the documents supporting this apparent authority defense were on the lost laptop computer. What is most damning to him is that when he presented the recipient of the No Mo Ravens email address with child pornography, the response isn't a thank you for your work or where did you get this? It's, yuck, I don't want kiddie porn. This is scary stuff. And no rational person would think that they were working with an FBI agent after receiving that kind of a response. No legitimate law enforcement agent would reject the very evidence that they purported to be seeking in using this individual as some sort of an informant or a cooperator. So the district court, in deciding that no rational jury would have found that Norweather's contention was credible and would have acquitted him on that basis, was not an abuse of discretion and has ample support in the record. So for that reason, I would ask this panel to affirm the district court's denial of the Section 2255 petition because Norweather's did not meet his burden of showing a reasonable probability that the outcome would have been different on either of his contentions, either the computer forensic review contention or the jury instruction contention. And unless the panel has any further questions for me, I will conclude my argument.
Hey, thank you, Ms. Murphy.
Thank you.
Mr. Roy.
Thank you, Judge. One thing I want to clarify is we actually agree with the government that we haven't established prejudice on the forensics expert. That's not what we're arguing. We're not arguing that we've substantively won that claim, just that at the pleading stage, he's alleged enough to get a hearing on it. And a couple points I want to make on that is first, with the lack of an expert report, Judge Hamilton, Judge Maldonado, I'm sure you both saw many times in the district courts evidence of times where prisoners lose things in prison. It's very common in motion practice, even on the Court of Appeals, Judge Kirsch, I'm sure you've seen too in motion practice. Very common for people to lose things in prison. It would require extraordinary luck for someone in Mr. Norweather's position to have the expert report when it was never submitted at trial. And his entire claim is that his attorney erred by not presenting the evidence from the expert report. So it's circular to require him to then have the report as part of his claim. The other thing I want to mention is, Judge Kirsch, you mentioned during the previous case about how evidence can be both documents but also testimonial statements. Here, Mr. Norweather's pro se 2255 motion and his reply were both signed under penalty of perjury. He signed them as affidavits. So as much as the government was arguing in their briefs that there wasn't affidavits or evidence provided, their argument really is that we shouldn't consider Mr. Norweather's own testimony to be evidence. But it is still evidence. Unless there's any further questions, I will see.
All right, thank you, Mr. Roy.
Thank you.
Okay, our next case is Royan versus Chicago State University, appeal number 24-1734. Mr. Bloom.
Good morning, Your Honors. Good morning to opposing counsel. My name is Will Bloom on behalf of the plaintiff appellant, and may it please the court. Had Ila Royan not told Dr. Patel on March 6, 2019 of her disability, she would have graduated from pharmacy school that fall. The district court erred in making a factual finding that Ms. Royan left her rotation voluntarily when there is undisputed evidence that Dr. Bishop told her to leave and then directed her by email not to return after Dr. Patel berated and criticized her in an effort to push her out. Leaving this rotation was the stated reason for the F grade she received in that rotation, which precipitated her removal
Mr.
from...
Bloom, can I ask you, can you separate between the two rotations? I think your brief spends a lot of time talking about the first rotation, but you spend much less time on the second rotation. And she received, I think, a failing grade in the second rotation as well, the Kerner rotation.
Yes, Your Honor.
And the law requires, at least I think, that discrimination be the sole cause of her dismissal. And so can you tie what if she receives a failing grade in the second rotation, what's your best case that based on the failing grade in the second rotation, not but for cause, but sole cause?
Absolutely, Your Honor. I would make two arguments on that point. One, Ms. Wren would not have been in Dr. Kerner's rotation but for the discrimination she experienced starting in March of 2019.
Well, you just said but for.
That was the sole cause. That discrimination was the sole reason that she was even in Dr. Kerner's rotation.
Okay, but she failed this Dr. Kerner's rotation.
Well, and I can speak to that point as well. Dr. Kerner, as the testimony and the evidence shows, had previously told her that he would fail her if he had her again. Ms. Royan told that to the administration, to the defendant.
But was that based, did Kernan, is there evidence that Kernan says that because of discrimination?
Kerner doesn't say that. I don't believe there's any evidence that Kerner said that because...
So what's the evidence that the sole cause of her termination was discrimination?
I think the sole cause is that it was that discrimination that had her in that rotation in the first place. It was entirely downwind.
But that's two steps removed, I guess is what I'm saying. She was discriminated against, so she was put in Kernan's rotation, but she was fired because she failed Kernan's rotation. So how do you tie, you see where the disconnect is for me?
I understand. The fact that Kerner's that an F in Kerner's rotation would lead to her dismissal from the program is only because of the F in Dr. Patel's rotation. It's entirely downstream, and so it's not an independent cause. It's, the sole cause versus but-for cause distinction.
So you're not arguing that she failed Kernan's rotation because of discrimination?
We're not
arguing she would have been in Kernan's rotation but for discrimination.
We're arguing that the discrimination was the sole cause for her being in Kerner's rotation, which
was not the sole cause for her dismissal, because she failed.
She failed in a rotation that she was told from the start, you were going to fail if I get to grade you again, which is something that Ms. Royan told the administration immediately after being assigned to Dr. Kerner's rotation. She said, this professor has previously said, I'm going to fail you if I can, made that threat, and the administration took no action. And the administration failing her in Dr. Patel's rotation, putting her on academic probation, refusing the appeal, and then putting her in rotation with a professor who had said, I'm going to fail you, is all a product of the discrimination. The discrimination is the sole cause that any of this was happening. And I think this gets to the distinction that I think you're raising between the sole and but-for standards. As we argue in our briefing, that distinction is relevant in mixed motive cases where there is both legitimate and illegitimate reasons for an action. Under the ADA standard, the fact that there is a but-for cause that is illegitimate, that is because of disability, is enough even where there are also legitimate causes. The Rehab Act standard says that where there is a mixed motive like that, a claim cannot maintain because the discrimination over disability has to be the sole cause. Here, there is one sole cause, and it is the disability. Everything that happened to her after she disclosed her disability to Dr. Patel falsely asserted that she was going to hurt herself to the administration. All of that was solely caused by discrimination against her on the basis of that disability.
Mr. Bloom, I was looking, maybe you can help me, for evidence that plaintiff disputes mistakes identified by Dr. Kerner or by Dr. Patel in her substantive rotation work.
We don't dispute that she made mistakes. All students make mistakes. We do dispute that those mistakes were the reason for her F in Dr. Patel's rotation and being placed in this process. As the written email evidence shows, she was given that F for leaving her rotation and not returning, even though Dr. Bishop told her to leave.
And how about Kerner?
Kerner, there's very little evidence as to why that failure happened. We don't have much evidence on that, but as we've said, the fact that she was in front of Kerner at all was a consequence of the discrimination. And Kerner said before any of this even happened, it was a foregone conclusion at that point, he was going to fail her.
Well, if he could, but I guess I'm trying to. We're talking about somebody who is training for a safety critical profession, right?
Absolutely.
And at least as I reviewed Dr. Kerner's emails, he's identifying some pretty significant errors, and I gather those are not disputed.
I don't believe the summary judgment motion below got into the details of the errors he raised. I think the important thing to note here is that she was getting an A in every other class that she had at this time. And if we win this case, it doesn't mean poof, Ms. Royan is a pharmacist. It means she has an opportunity to complete her degree. If she goes back and genuinely can't hack it, that will be borne out.
Could you
every other excuse me, Your Honor.
No, go ahead.
Every other course she was in, she was getting an A. On another rotation, she got a letter of commendation. And it's important, I think it's worth noting that the other cases that defendant cites on, otherwise qualified individual show far greater and far more objective standards of being unqualified. Novak involves multiple objective exams that the plaintiff failed. Ewing involves a plaintiff who got the lowest score ever on the medical examiner test. And that's simply not Ms. Royan's situation. She was excelling.
Could you address the Kahn case?
The Kahn case?
Yes.
Yes. So in the Kahn case, the student had failed 4 classes, was on track to fail 3 others. Those were mostly on the basis of objective exams, as I recall the details of that case. I think those are conditions quite different than the facts in this case. And I think the Kahn standard says, we should defer to academic decision-making, academic opinions, but only if that professional expertise is actually being exercised. Here,
one of the points, however, in Kahn is that the school there had been granting a number of accommodations for the student's disability, which weighed pretty heavily against a finding of disability discrimination. And we have that here, as I understand the fact pattern.
Yes, I think the difference is here, the F that she was given in Dr. Patel's rotation, which precipitated this whole course of events, was not for failing academic standards, it was not for underperformance. It was explicitly, we have documentary email evidence that F came because she left the rotation and didn't return, even though we have undisputed evidence that Dr. Bishop told her to leave that rotation, and an email to her indicating do not return. I'd like to reserve some time for rebuttal if there are any other questions.
Most certainly.
Thank you, Your Honor.
Okay, Mr. Herring.
Good morning, Your Honor. Counsel, may it please the court. The 3 points that I want to make, Your Honor, why this court should affirm summary judgment in favor of appellee, Chicago State University. As the court has already acknowledged, the first point is the district court relied on the correct standard, which is sole causation. The appellant was unable to establish as a matter of law that she was dismissed from the program solely because of her disability. Under that standard, Your Honor, the court was correct in granting summary judgment under the Rehabilitation Act. The second point, Your Honor, the undisputed facts in the record show that she was not a qualified individual under the ADA because she did not meet the program requirements. And the third point that I want to make, Your Honor, is that she cannot establish pretext based on the undisputed facts in the record. Going to my first point, Your Honor, as the court has already acknowledged, it's clear even based on the strict reading of the statute that sole causation is the correct standard, and the district court applied that. Solely by reason of her disability, a person cannot be subject to discrimination. The cases also follow that: Connors versus Wilkie, Swain versus Wormuth. These are Seventh Circuit cases. The first decided in 2021, the second decided in 2022. As Your Honors have been discussing, clearly there was a failure in her meeting the standards as required in the second rotation by Dr. Kerner. And that alone shows that the issues that she raised with Dr. Patel, there's a disconnect there, which shows that it couldn't have been the sole disability discrimination, couldn't have been the sole reason for a dismissal. Key facts to understand is that the academic committee were the decision makers who put her on that probation and decided that she needed to take another rotation and take remedial steps. The academic committee did not know of her disability, and Dr. Kerner, the facts in the record show, did not know about her disability. So based on those undisputed facts, she cannot show that disability was the sole reason for her dismissal. As far as the...
So who was the actor who supposedly said you're too sick for this program?
I think she alleges that Dr. Patel, who was a preceptor at the University of Chicago, allegedly made that. Dr. Patel denies that.
I thought she also said that the dean had said that.
The dean of Chicago State University, that's
Yes.
correct.
Okay, so we've got the dean of her program, allegedly, but we have testimony to this effect saying you're too sick for this program, right?
And this testimony from, self-serving testimony from the appellant, yes.
I don't care if it's self-serving or not. You're familiar with our case law.
Absolutely.
That has corrected that
Absolutely.
earlier departure from summary judgment law. I'm trying to picture an employment case, for example, where the CEO says, you're too Catholic for this job, or you're too black or too white for this job. Wouldn't that seem to suggest that there was a decisive role played by religion or race?
Well, I think under these facts, Your Honor, that the Academic Standing Committee is the decision maker that made the decision when she failed the first rotation, and it was her, and there's emails in the record where she says it's her decision to leave that rotation. When she made that decision to leave the rotation, there's consequences. She subsequently got an F in that rotation, and the Academic Standing Committee
She says she was following Bishop's instructions, right?
That is what she's alleging, or that's what she's testified to afterwards. But the emails, and there's a clear email from her where she says it was her decision to leave, and that no matter what, she wasn't going to go back to that rotation. There's also facts in the evidence where Dr. Patel called and asked her to return to that rotation, and she didn't. Regardless, Your Honor, she had another opportunity given by the Academic Standing Committee to go to a second rotation, which is critical. This is the reason why she was dismissed from the university, because she failed the rotation in that for Dr. Kerner. And as Your Honors have pointed out, there was no basis for Dr. Kerner, at least no evidence in the record, to suggest that Dr. Kerner made any decisions regarding her performance based on her disability.
And she's not even arguing that, right? She's not arguing that Dr. Kernan failed her because of her disability, or that there's evidence in the record that he failed her because of her disability.
That's correct, which is, I think, critical and fatal to her claim under the Rehabilitation Act, which she must argue and show and prove that disability was the sole reason for her dismissal. But the sole reason for her dismissal was because she failed that second rotation with Dr. Kernan. That goes to my second point, Your Honor, that she couldn't be a qualified individual under ADA because she didn't beat the program requirements. The university followed the procedures in its student handbook, which makes clear that if you fail a rotation, and I should go back, counsel spends a lot of time saying that she got great grades, B's, C's, A's the first 3 years. But the requirements of the program is that you complete those courses, and that you also complete the rotation in the 4th year. And if you fail to complete the rotation satisfactorily, then you are going to be dismissed from the program, and that's what happened here. The university followed the handbook in that when you fail a course, you get put on academic probation. She got a second opportunity. She went before the Academic Standing Committee. They decided to give her that opportunity. They put her with Dr. Kerner. That was a decision the Academic Standing Committee made. She had an opportunity to pass that rotation, correct those issues, but as the facts and the evidence, the facts and the undisputed facts in the record show that she was unable to meet those standards, that she failed that rotation. And because of that, that's the reason why she was dismissed. I also want to address one last point is that she can't show pretext. The evidence, undisputed evidence in the record shows that, again, the Academic Standing Committee, which consisted of multiple members, faculty, heads, a dean of the Academic Student Affairs, department chairs, made a decision to put her on the path that gave her an opportunity to succeed, and she failed that. Again, there's no evidence in the record that they knew of her disability. With respect to, there's evidence in the record that the CSU had given her plenty of opportunities historically because of her disability in terms of leave of absences. In 2016, 2017, there's no reason to believe or any reasonable inferences to give to her to suggest that all of a sudden that the university would somehow come up with some scheme to discriminate and dismiss her based on her disability, when the history shows in the record that in fact have given her several accommodations and in fact granted her leave of absence to be successful in the program. And I also want to point out, which is one fact that I think appellant relies on exclusively, is that Dr. Patel, which is a University of Chicago preceptor, not a professor of Chicago State University, Dr. Patel, there's evidence in the record that she in fact criticized Ms. Royan's performance prior to March 6th, when she suggested that that's the reason she had disclosed her medical conditions, and all of a sudden that's the reason why Dr. Patel wanted to exclude her from the program. But the evidence in the record shows that her performance had been critiqued prior to March 6th. She disputes the severity or disagrees with those critiques, but she does admit that she had those issues. She also,
where do we find that?
That's in the record, Your Honor. There's an email exchange where Dr. Patel, in her evaluation, says that these are critiques that she had for Ms. Royan prior to the March 6th date, where Ms. Royan alleges that that's when she disclosed her medical conditions.
That email was after the March 6th meeting, is that right?
So that was one email, Your Honor, but there is evidence in the record that prior to March 6th.
That's what I'm trying to ask you.
Correct.
What is that evidence? Because I thought that was all generated after the March 6th meeting. Maybe I misunderstood.
I don't have that correct. I don't have that exact cite, Your Honor, but there is, and it's in the record. I can't cite that.
Can you give us a hint as to what it consists of? Was it in an email? Was it in deposition testimony? Because I thought that Dr. Patel was late with her evaluation. And the point, the sequence here could be material.
Well, I don't have that exact pinpoint. I can certainly follow up with that, but I think even moving away from that, I don't know that that is material, and I see my time is up, because I think the focus is on her performance in Dr. Kerner's rotation, which is what in fact led to her dismissal, and that's the reason why she can't show.
Well, I understand that's your theory, but we were talking about the Patel experience, and you were telling us that it's documented that Patel was critical of her before 6th. So that's what I'm looking for.
I can't pinpoint to that site, but there is evidence in the record, Your Honor, that Dr. Patel did have criticism.
Is it in your summary judgment papers in the district court?
It is, Your Honor.
Thank you.
Okay, thank you, Mr. Herring. Mr. Bloom.
Thank you. I'd like to just make 2 quick points of fact and 2 quick points of law. Opposing counsel mentioned that the Academic Standing Committee made these decisions and they had no knowledge of her disability. Setting that question aside, their role is ministerial. As he said, they were simply following the established procedures, and the decision to give her an F had been made prior to the meeting of the Academic Standing Committee. We have an email from Dr. Johnson indicating that she should be awarded an F. This is Dr. Johnson, who was well aware of her disability, advised her not, reprimanded her for sharing that disability with Dr. Patel. Also, on the qualified individual and the idea that she somehow failed the requirements of the program. The only requirement of the program that's been identified that she failed was getting the F in this class. That F, we argue, is because of her disability. That's what this case is about. On the law question, the standard for a Rehab Act claim, opposing counsel pointed to Connors and Swain. Neither of those cases actually turn on causation. Connors says causation is not the issue here. Neither of them even explain what the standard is. They just say it's a stricter standard, but don't actually say how to apply it. We address what that distinction is in our opening brief. And the final legal point I'll make here is that both my presentation, your questions, opposing counsel's presentation have largely centered on the facts of this case. And this is a motion for summary judgment. It seems obvious both from the briefing and oral argument that there are material questions of disputed fact here, and those questions should go to a jury to decide. Thank you.
Okay, thank you, Mr. Bloom. The case will be taken under advisement. Our last case of the day is Siddiqui versus National Association of Broadcast Employees, appeal number 24-2315. Mr. Pierce, whenever you're ready.
Good morning, and may it please the court, counsel. The district court committed reversible error in this case when it rejected long-standing precedent from the Supreme Court and from this court in refusing to allow the plaintiffs to file a fee petition after succeeding on their claims under the Labor Management Reporting and Disclosure Act under either the common benefit or the bad faith doctrine. This is true regardless of the standard of proof that this court applies to this case. With my time this morning...
You mean the standard of review?
I do, I apologize, yes, the standard of review.
So do you concede that the standard of review is abuse of discretion?
No, Your Honor.
Why?
So the abuse of discretion standard, and I did want to address this first, so I will. The abuse of discretion standard that's generally applied in reviewing fee awards by the district court calls for a high level of deference to the court's determination of, for example...
Are you talking about it's only review, we only review for abuse of discretion the amount of the fee, but we don't review for abuse of discretion whether to award fees?
So there is a line that this court has drawn in terms of the amount of fees to be awarded, the rates that are requested. All of that falls within the discretion of the court, of the district court. When fees are denied based on a legal principle, the Seventh Circuit has held that that is not the same level of deference that's owed.
That's not what the district judge did here, not even close. The district judge recognized the theory. The district judge observed that perhaps the common benefit of theory shouldn't apply, but even if it does, that fees were not... He said that the exception should not apply here, and then he explained in detail the reasons for his decision. I mean, fees issues are inherently within the district court's discretion. Full stop.
I respectfully, Your Honor, I think that is typically the case. Here, we were not at the point of submitting our records to see how much time had been spent. We were not determining whether the time spent.
What difference does that make?
Well, this is more of a threshold question that was being decided here, which is, could fees be awarded under the common benefit or the bad faith?
What do you think was the legal question the district court was answering?
The district court was answering... Yes, the district court was answering the question of whether the common benefit doctrine applied in this case.
And whether a fee award of any amount was appropriate. And why is that not discretionary under Hall or our case law? I agree it's not left to whim, but we got an explanation from the district judge.
Well, the district judge's decision and the explanation in this case, he did set out by, I think, correctly recognizing what the legal standards are under both of these standards, and he did refer multiple times to the court's discretion. However, in actually applying the facts of this case and the court's own findings to those standards, completely ignored the established precedent from the Supreme Court in Hall v. Cole and all the cases that have followed. So,
in what way ignored? He's discussed them. He says he's applying them. He says, I've got, in essence, discretion. As I understand it, by the time this issue gets in front of him, there's a second trusteeship, is that correct? And this war of attrition is going on. As he said, the battles are not over. Why is that an abuse of discretion?
Well, assuming that an abuse of discretion standard applies, obviously that discretion is not without bounds. The decision has to be based on some reasonable justification, cannot be arbitrary.
So let me give you an example that, at least as a former district judge, came to mind. First time there's a dispute in a new civil case about discovery, a motion to compel. The rules tell the district judge, in essence, presumptively, a fees should be awarded on a discovery dispute. But the district judge knows that this is early in the case, and I can either stir this up more, or I can try to put this to rest by denying a fee award the first time and kind of discouraging unnecessary discovery disputes. The battles are not over comment here kind of brought that situation to mind for me. Is that unreasonable by a district judge?
So I think in terms of the battles not being over and the court considering any developments that may have happened after the trusteeship was dissolved, I think that is one of the focal points of the district court's decision, and also the arguments of the appellees here. But I think it's important to consider what the alternate reality is that the district court and the sector in this case are presenting as, being a better option than what happened here. What happened here was a bad faith illegal trusteeship was dissolved, and the elected leadership of the local was put back into control of the local. Had that not happened, then the trustee who was illegally imposed over this local would have remained in power, presumably to the present day. And the district court found in granting the temporary restraining order in this case that every day an illegal bad faith trustee wields power and control over the local, that is irreparable harm to the union and its membership. So
I understand that, I think, but that doesn't tell me why this was an abuse of discretion.
So I think one of the fundamental flaws in the district court's decision, which we do consider to be reversible error here, even under the abuse of discretion, with respect to bad faith, the court stated the standard, confirmed that you do not need a showing of bad faith in the course of litigation to award fees, and then refused to award fees solely because there was no finding of bad faith in the source of in
Where
the
do
course
you
of
get the solely because there? Mm-hmm.
So the district court's decision does not spend a lot of time on the bad faith doctrine specifically.
Well, you just told us that was the flaw in the reasoning. Please point me to it, the best evidence of that.
Yeah, Your Honor, I don't have the decision in front of me. On rebuttal, I can certainly address that. But the bad faith and the common benefit are two standalone bases that fees should have been awarded here. The district court spent substantially more time on the common benefit analysis.
If fees were paid now, who would they be paid to?
The fees would be paid to the plaintiffs, the 7 rank and file union members who brought this lawsuit.
They were reimbursed by the union, however, correct?
They were not reimbursed by the union, no. There was a vote by the unions. The local executive board voted to pay a portion of the fees that had incurred while this lawsuit was still ongoing in the merits. That payment was made to plaintiffs' attorneys. That was a partial payment to support that litigation, was made on the basis of the local union finding that this lawsuit was brought on behalf of all the members and that it brought a common benefit to the membership.
By the time the plaintiffs were installed in leadership, correct?
Correct.
Reinstalled. Yes. Okay.
That's correct.
So, I guess I'm still trying to understand whether fees, if a fee award at this point would be paid to the union or to the plaintiffs or divided between them.
Right, and I think we addressed this point, I think in our reply brief, that any award of fees belongs to the party, and the courts do not really normally get into what amount needs to be paid to attorneys, what amount has been paid or could have been paid by a third party. The award is really to the plaintiffs. So I think it's not a point that the district court looked at The district court did not reference that payment in its decision, and I don't think that should be a guiding principle here. Very briefly, because I know I'm already into my rebuttal time, in terms of stating and then ignoring the law, the district court in this case actually muses that if Hall v. Cole were presented to our current Supreme Court, that case may not have come out the same way, and in fact, our current Supreme Court might overturn that case. This prediction of what might happen in the future is not a basis to reject fees, and in fact, by doing so, the district court put itself above this court and even above the U.S. Supreme Court in deciding what precedent to follow.
You're reading an awful lot. Where do you think he says that? He obviously makes the comments. Where do you think that's driving his decision?
Well, Judge, that has to be a point driving the decision. Number one, it wouldn't have been included in this oral ruling if it were not worth noting to the judge. And number two, I don't think...
if I muse that the controlling precedent might, in some case, might be getting a fresh look or might be criticized, then that taints my thinking inevitably. Is that the way you're reading this?
No, Your Honor, but
sounds like it.
Reading the district judge's decision, there does not appear to be any other reasonable justification aside from his doubts about the continuing vitality of this standard.
How about battles are ongoing, and let's not make this worse than it already is.
Judge, I see I'm out of time. If I may
Please
respond
answer.
to that point. Yes, the battles that are ongoing, I think actually support an award of fees here and should have led to an award of fees. What they represent is the sector in this case, the national union and its leadership from Washington, D.C., continuing to go after, retaliate, and single out those individuals whose politics it didn't agree with. And as a result, removed the leadership that had been elected to this local union. To the extent those developments after the dissolution of the trusteeship are considered at all, they actually favor an award of fees, because to refuse to award fees here, as Hall v. Cole pointed out, the Supreme Court pointed out, would effectively would do away with the entire provisions of the LMRDA meant to support union democracy and to crack down on abuses of power and corruption by union leadership.
So fee awards are mandatory.
Fee awards are not mandatory, no, Your Honor, but this case presents the exact circumstance under which the Supreme Court and all other courts have found them to be necessary and appropriate. Thank you.
Okay, thank you, Mr. Pierce. Mr. File.
Thank you, Your Honor. Counsel, may it please the court. It is truly disappointing that we are here today. What plaintiffs apparently fail to realize is that the federal court system is not Alice's restaurant. You can't always get anything you want. And when you don't, that does not give you a good faith basis to file an appeal. This court said it best in a state of Borst versus O'Brien: there are few matters more wasteful of judicial resources than ancillary litigation over an attorney's fee award. This case is no different. The parties in this case entered into the consent judgment at the district court as a result of settlement. The entire purpose of doing so was to avoid further running of the legal meter and to put an end to the litigation once and for all. The defendants entered that consent judgment under the reasonable assumption that the parties would accept whatever outcome the district court decided when they agreed to submit the issue of plaintiff's attorney's fees to the discretion of the district judge. Unfortunately, it seems plaintiffs had different intentions. Here we are today, still needlessly running the legal meter and wasting judicial resources. This appeal is utterly baseless. The plaintiffs are clearly mistaken, if not downright being disingenuous, to argue that the standard of review on appeal is anything other than the abuse of discretion standard. In fact, plaintiffs' counsel expressly admitted that to the district court, that the decision to award or not award fees under either the common benefit or bad faith doctrines is discretionary. At the October 2023 hearing, the district judge asked plaintiffs' counsel, quote, "If I find either bad faith or common benefit, that would authorize an award of fees, but it does not require it. Am I right about that?" Plaintiffs' counsel responded, "Yes, that is correct. It's not mandatory. It's not fee shifting." Yet now on appeal, plaintiffs have pulled a 180. They're taking the position that a district court is required automatically to award fees anytime a lawsuit confers a common benefit or anytime there's evidence of bad faith, no matter how slight the common benefit and regardless of whether the other party litigated the case in good faith. That is simply not the law. The leading Supreme Court case on the issue, Hall v. Cole, upon which plaintiffs most heavily rely, states, quote, federal courts in the exercise of their equitable powers may award attorneys' fees when the interests of justice so require. The key word in that sentence is may. May is a permissive word. It is by definition discretionary. It means that the district court may choose to award fees or it may choose not to award fees depending on the circumstances. The plain language of Hall establishes that even if there is a common benefit or evidence of bad faith, a district court may still choose not to award fees if overriding considerations or the interests of justice do not indicate the need for such a recovery.
Mr. File, I read your brief as seeming to want to debate the district court's findings earlier by Judge Feinerman of bad faith and Judge Shaw's finding of common benefit. Are you accepting those findings or debating?
Yes, absolutely. Judge Shaw issued his ruling, and he found that there was some common benefit, albeit slight, and that there was bad faith in the imposition of the trusteeship, but not in how the defendants conducted the litigation. Judge Shaw then examined the rest of the totality of the facts and circumstances of the case and properly applied the law of common benefit and bad faith doctrines to the facts of this case. Other facts that were considered and were certainly relevant was that there was, one, that the defendants litigated in good faith, that there was overwhelming evidence of actual harm to both the local and the national union as a result of the litigation, in that it allowed the restored leadership to engage in rampant, gross financial mismanagement of the local for nearly a year following the TRO, which eventually led to the CWA stepping in and placing them back under trusteeship to stop that gross financial mismanagement, which has since sparked an entirely separate litigation at the district court.
That's still pending?
I'm sorry,
still pending?
Yes, that is. A First Amendment complaint was recently filed. Then there's also the fact that plaintiffs' attorneys had already been paid the $94,000 out of the local's treasury before they made the request to the district court for fees. That's a particularly relevant fact in the common benefit analysis of this issue. Plaintiffs are arguing that it's irrelevant because in other statutory fee shifting cases, the courts don't look at whether the attorney's bills had already been paid, but they're missing the point yet again. This is not a statutory fee shifting case. This is not a Rule 11 sanctions case. This is under the common benefit or bad faith doctrines. And under the common benefit, which is an offshoot of the common fund doctrine, the purpose is to spread the fees proportionately among those who benefited from the suit, not to saddle the losing party with the expenses. In Skelton v. General Motors, this court explained the difference. In a statutory fee shifting case, it's the parties who may seek reimbursement of fees, whereas in a common fund case, it's the attorneys who have the claim to compensation. Therefore, in this case, it was entirely proper for the district court to consider that payment, and it would be proper for this court to consider it as well in affirming the district court's ruling.
But it would, if I understand it correctly, in the common benefit theory, it would be appropriate, or at least could be appropriate, to award the fees and order the international union to pay those fees for the dissolution of trusteeship, correct?
Had the district court found that the facts and circumstances of the underlying litigation justified awarding fees under the common benefit doctrine, under Hall and its progeny, then yes, it could have done that. There was
Thank you.
caveat. Well, there was the issue that I think the district court asked the same question that you just asked the counsel, which is who gets paid. That was a question that was brought up at the lower court. The district judge did not address it in his decision, and so I don't know that it really needs to be addressed much further here. There's another major flaw in the plaintiff's arguments. If they were to be accepted, then it would effectively rewrite Section 304 of the Act to include automatic fee shifting, which does not exist in the statutory text. Respectfully, the federal courts do not have the authority to rewrite our federal laws. That belongs exclusively to Congress. If, as plaintiffs have argued, every successful lawsuit to dissolve a trusteeship under Section 304 results in a common benefit to the entire union, and if, as they've argued, district courts are prohibited from examining any other facts or circumstances beyond just that common benefit at the moment that the trusteeship was dissolved, then every successful suit under Section 304 would automatically result in fee shifting under the common benefit doctrine. Similarly, if, as plaintiffs have argued, fees should be awarded anytime there's evidence of bad faith in the imposition of a trusteeship, but not in the conduct of the litigation, then that too would result in automatic fee shifting in every successful case, because bad faith is a requirement to succeed on a Section 304 claim. If a trusteeship was not imposed in good faith, then it was imposed in bad faith. Congress did not include statutory fee shifting in trusteeship cases under Title III, but it did include fee shifting in other cases arising under Titles II and V of the LMRDA. Therefore, Congress has expressed its intent that it did not want there to be fee shifting in trusteeship cases. So with that, we would ask...
Sounds like a good argument against Hall.
I'm not asking the court to overturn Hall. I think, again, Hall says that the district court may award under certain exceptions, rare exceptions to the American rule, but it does not say that you need to award fee shifting. And so we would ask this court to heed the Supreme Court's warning from the Alyeska pipeline case, which states that the courts are not free to fashion drastic new rules with respect to the allowance of attorney's fees. It is not for the courts to invade the legislature's province by redistributing litigation costs. In closing, again, I feel the need to apologize to this court. I, too, can think of no greater waste of judicial resources than this appeal, especially considering that the whole point of the parties entering the consent judgment was to avoid such needless and wasteful ancillary litigation. Accordingly, we're asking this court to deny plaintiff's appeal, to affirm the district court's ruling, and we would also ask the court to exercise its authority under Appellate Rule 38 to award...
Have you made a motion to that effect?
We have not, but we...
Are you familiar with the rules on that?
I was not certain when the timing went to file that, but we can certainly are prepared to file that motion. I'm assuming following a ruling would be the appropriate time.
Such motions are also subject to Rule 38 sanctions.
Okay. Well, I will leave it at that.
The battles are not over, as the district judge said. We can make this worse, or we can make it or not worse.
I understand.
Is my message clear?
I understand. I'm getting your
you.
message, yes. We are asking the court to deny the appeal and affirm the district court's ruling. Thank you.
Okay, Mr. Pierce, would you like some rebuttal? We'll give you a minute if you have anything you'd like to add.
Yes, thank you, Your Honor. Very briefly. Again, I think this court and this case really comes down to the purposes of the LMRDA, which are stated in that statute, to prevent union corruption, to promote union democracy. And the district court in this case, in terms of matters still being disputed, the fight's not being over, the district court said this really just comes down to a dispute over who should run things. I think the district court was right about that. But the question is, who should run this local union? Its membership or the leadership of the National Union in Washington? In this case, the members of the local union prevailed and defeated the bad faith unlawful trusteeship. As a result, union democracy prevailed. And for that reason, and for all of the reasons stated in Hall v. Cole and its progeny, we believe an award of fees should have been entered in this case and would respectfully request this court to reverse the district court's ruling. Thank you.
Okay, thank you to both counsel. The case will be taken under advisement and the court will be in recess.